America's uniquely democratic patent system. How did the U.S. create a patent system for everyone? The men who led the revolution and wrote the Constitution wanted to stimulate the rapid growth of industry to ensure the new nation's economic survival. The survival of the United States was far from certain in those days. America's agrarian economy depended heavily on imports. Britain, meanwhile, had a population 3 times that of the United States and was the unrivaled leader of the emerging Industrial Revolution. It was, therefore, a critical task of the leaders of the new American nation to design institutions, including a patent system, that would encourage economic activity and investments to spur the growth of America's primitive economy. Because America had no significant capital or commercial assets, the new nation had to rely on its 2 chief advantages: abundant natural resources and a population considered to be uniquely enterprising and independent-minded. Unlike the tenant farmers and laborers who made up the bulk of England's rigid class society, the vast majority of Americans were free-holding farmers, shopkeepers, artisans, and mechanics, the forerunners of what we today call the middle class. And as publisher Hezekiah Niles put it, they were possessed with a universal ambition to go forward. This ambition was America's principal asset, and the founders knew they had to find a way to unleash the creative and productive potential of their citizens. How can patents spur economic growth? In 1787, America no longer had access to Europe's vast resources and was left to its own devices. As Thomas Jefferson explained in a note to his daughter Martha, "We are obliged to invent and execute, to find means within ourselves and not to lean on others." The founders quite consciously created a patent system that would do what no other patent system in the world had ever done before: stimulate the inventive genius of the common man. The first thing they did was to affirm the rights of inventors and authors in the U.S. Constitution. Although the Intellectual Property Clause was ultimately adopted unanimously on September 5, 1787, there was much debate before it passed. Jefferson, in particular, had reservations about the wisdom of granting temporary monopolies so soon after Americans waged a bloody war of independence to end Britain's monopoly on trade and political power. But other delegates noted that a monopoly of trade is a far cry from the temporary incentives granted to inventors in return for the benefits they provide society. In the words of Louis Wolosky, Polish economic and political writer, "Inventors' rights under patents are called monopolies only from the poverty of language, which has failed to express in words a very important distinction." As historian B. Zorina Khan put it, rather than monopolists, patentees were viewed as beneficent contributors to progress, and the consistent goal of those who shaped the system was to encourage domestic ingenuity, whatever the social class of the inventor. Or, as James Madison put it in the Federalist Paper 43, the public good fully coincides with the patent rights of individuals. What made America's patent system unique? The real genius of the founders was the way they integrated democratic principles into the design of the world's first modern patent system. These were reflected in 6 fundamental innovations in our patent system that departed from European practice. First, the American system deliberately decided to have low fees, making patents affordable. The original patent law passed by Congress on April 10, 1790, set patent fees at $3.70, an amount that nearly any citizen could afford. Even after fees were raised to $30, they were still less than 5% of the filing costs in Britain. The results were dramatic. Whereas Britain's inventors often came from privilege, the vast majority of America's inventions came from humble beginnings. Second, the U.S. system simplified application procedures. The founders greatly streamlined the administrative side of patent applications. In the U.S., applications only needed the approval of a single patent office, which created repositories throughout the country where inventors could drop off their applications and models. Rural inventors could even apply for a patent through the mail, postage-free. This last perk for rural inventors turned out to have a big impact on the course of U.S. economic development. While most British industrial breakthroughs were confined to London or other big cities, U.S. inventions were widely distributed across urban and rural areas. The result was broader-based economic growth and less income inequality in the U.S. Third, the U.S. patent system sought to encourage the spreading of new technological knowledge, creating a virtuous circle of innovation. In Britain, patents were only open to public inspection for a fee and were not even officially printed, published, or indexed until 1852. By contrast, the first U.S. patent law explicitly stated that copies of patent specification together with similar models are to be made at the public expense and lodged in each state. In addition, a plethora of publications by government and industry enabled any citizen with an interest to keep up to date on the latest patent technologies. Fourth, the U.S. system required the examination of patents for validity. In a crucial departure from old world practice, the founders created the first examination system for patents to ensure their 1. Novelty, 2. Non-obviousness, and 3. Utility. But this was found to be cumbersome, so in 1793, a more simple registration system was established. It turned out, however, that without the examination of patent applications, the validity of issued patents began to be questioned. So the reforms of the 1836 Patent Act specified that henceforth, applications would be scrutinized by technically trained examiners to ensure that the invention represented a genuine advance in the state of the art. For the first time anywhere in the world, the criteria for granting a patent depended solely upon the merits of the application rather than the identity or the mere say-so of the inventor. But the situation was very different in Europe. In France, for example, the following caveat was printed on each patent. The government, in granting a patent without prior examination, does not in any manner guarantee either the priority, merit, or success of an invention. Imagine trying to interest a group of investors in your new invention with that kind of warning label attached to it. The fifth distinguishing feature of the U.S. patent system was the lack of any sort of working requirements. In the debate over H.R. 41, the bill that became the first U.S. patent law in 1790, the Senate suggested requiring patentees to make products based on the patent or license others to do so. But the House rejected this as an infringement of patentees' rights. Indeed, the founders believed working requirements would only strengthen monopoly power and skew invention toward incumbent industry by limiting patents to those who already owned the factories needed to manufacture products from their inventions. By 1865, the U.S. per capita patenting rate was more than triple that of Britain's, according to the annual reports from the commissioners of patents in both countries, and by 1885, it was more than quadruple that of Britain. Each U.S. patentee was also far more prolific than his or her British counterpart. By mid-century, the U.S. was patenting 5 times the number of inventions as Britain each year, even though the populations of the two nations were then equal in size. Lastly, the U.S. system was designed to create a market for new technology. It provided an explicit provision for the sale of patent rights that both the courts and the U.S. Patent Office acted to facilitate. Why facilitate the buying and selling of patents? Because doing so enabled ordinary inventors without the capital to commercialize their own discoveries to still participate in inventive activity and earn income by licensing or selling their patents to enterprises that could. With this ability to license patent rights, along with low application fees, inventing emerged as a new career path for thousands of poor but technically creative citizens. It also proved to be a powerful means of mobilizing capital for investment in new technologies and their commercialization into new products and services for society. That patents could be used as tradable assets was a wholly unique feature of the American patent system. By 1880, 85% of all U.S. patents were licensed by their inventors, compared with 30% of British patents. Patent licensing, in fact, was the principal means by which new discoveries were commercialized in the decades before the early 20th century emergence of in-house corporate R&D departments. Publications such as Scientific American were founded specifically to facilitate the trade in patents, and it regularly featured lists of new and interesting patents, which commercial enterprises then licensed or purchased to use in their product development efforts. The founders' decision to foster patent licensing proved crucial to America's rapid technological progress and economic growth. Indeed, patent records from the 19th century reveal that more than 2/3 of the great inventors of the Industrial Revolution, including Thomas Edison and Elias Howe, licensed some or all of their patents to outside enterprises for development into commercial products. In sum, these 6 unique features of the U.S. patent system all had a powerfully beneficial impact on the nation's economic growth. But none of that would have been possible were it not for the democratic rule of law in the U.S. and the critical role played by the legal system in interpreting and enforcing America's revolutionary patent laws.